Hello, Marco. How are you?
Hi, Maya. Thank you for having me. I'm excited to be
Well,
here today.
I'm excited to have you as a guest. It's always very nice to see you. You're always very generous with your time and always willing to help your colleagues and junior lawyers. So, thank you for being my guest here for the series. It's a Wicked series, Who Cares? And today, actually, Marco, we're going to be talking about something I know you really care about this subject, and it's jury trials. You are one of the go to lawyers for everything that has to do with jury trials. And I thought that maybe this is your opportunity to explain to us why you like these trials so much. But before that, if you can maybe just give some brief clarifications about like the differences between a judge alone trial and a jury trial. We'll start with that and then we'll get into why you like jury trials so much.
Okay. I mean, as lawyers, we know generally what the difference is procedurally between a judge alone and a jury trial. Obviously, to have a judge decide the case is one way of having your client's matter adjudicated. It's not, and I know I advocate for jury trials a lot more than judge alone trials, but I think it's also case specific. If I could be honest, my opinion is that when you have a case where if you have a factually innocent client or you have a good legal issue, a good defense, um, a positive defense that you can raise as well, or you have a case where you have good reasonable doubt that you can establish, even you can see that from the start. Of course, those are the types of cases where you would consider having a judge alone trial, in my opinion, because the judges will understand the law, they'll understand the how to apply the law, and you need them to apply the law. I advocate for jury trials a lot because I oftentimes have cases where there are no defenses, or the defenses are something that um, I don't believe a judge will accept in terms of a defense, because as we know, sometimes in a judge alone trial, the factual guilt of our clients might come out. And I believe that the judges can disabuse their minds to the factual guilt if there is a valid defense. And we see that a lot, for instance, in impaired driving cases, where, in an impaired driving case, person, for instance, blows into a device, they've blown over the legal limit, they are factually, we could say, guilty of the offense. But oftentimes the judges will acquit if there are uh, legal defenses or charter issues that apply to those defenses. So that's a good example, in my opinion, of judge alone trials. But when the stakes go up and the consequences get higher, and the technical defenses that you might be running are not things that you feel a judge is going to decide in your favor, I feel that you have a lot more flexibility in a jury trial. And the reason why you have more flexibility in a jury trial is because a lot of the prejudicial information that the Crown has and the judge will know about doesn't get before the jury. So you have an opportunity to sanitize the evidence and focus the spotlight specifically only on the facts that will be applied to this one specific case. So if you can focus the evidence and you focus the triers on just the facts that are going to be relevant to the determination of guilt and innocence, I feel that juries take their jobs very seriously and try not to let themselves be prejudiced by any other prejudicial information that comes in, because they're solemnly sworn to do that. They also are, especially in today's day and age, I think there's this big movement of not judging people for superficial things. You're not going to judge somebody because of the color of their skin. You're not going to judge, you shouldn't. And there's a dynamic, there's 12 people, and those 12 people coming together will create a tension in that room to say, look, even if we believe he's guilty or we think he's guilty, do we believe it beyond the reasonable doubt? It's a very high standard. In the last jury trial I ran in the spring of this year, there was in short order, it was a bank robbery where the client was arrested in the vicinity of the robbery with the GPS tracking device and the money from the bank. But the Crown failed to lead appropriate identification evidence. We ran an identification case. The judge had to give a charge to the jury on identification. And the jury came back with a very, very interesting question, which was, what do we do if, or how do we balance the common sense inferences that lead to guilt against all of the doubts that are created by the absence of evidence, meaning absence of evidence of identification and so on, and other parts of things that I pointed to. And that question was interesting because it showed that the jury was probably sitting in the room all thinking, this guy's guilty. We know he did it, but has the Crown proven it? And ultimately they acquitted. And it's like,
based on the law.
Based on the strict application of the law, because the judge had to instruct them that these are not competing issues. If you have doubts, then you have doubts, because beyond the reasonable doubt is much closer to absolute certainty. And he instructed on that point. And after that instruction, the jury acquitted. And it was the type of thing that reinforced my belief that in cases where any judge would have convicted this individual because the case was overwhelming against them, not to mention his criminal history where he was already designated a dangerous offender for robberies, right? So there's all of that prejudicial stuff that makes it very, very hard for a judge to turn a blind eye to that. Even though they don't, they're going to look at the overwhelming amount of circumstantial evidence and convict. Whereas a jury, and you have this opportunity to play with the facts in the sense of, perhaps you stay quiet on some points. You don't let the Crown lead certain evidence. The Crown forgets something, you don't draw attention to it. And then you can go to the jury and point to absence of evidence or point to other things and make a reasonable common sense argument to the jury that the Crown hasn't established their case beyond the reasonable doubt. And so that's why that's the difference. It's case specific. And I always think that, we go back to what it says. There's the public interest in the adjudication of the case on its merits that we know from, the 24-2 testing grant, which is the Supreme Court of Canada telling, judges, when you're considering excluding evidence, when you're considering things in charter breaches, you have to consider the public interest in trying case on the merits. And I think that even in factual determinations, judges always have that in the back of their mind. They're saying, there's a public interest that on the merits of this case, this person needs to be convicted, like my client in that last case. He needs to be convicted because he did this. We know he did this. And, even if we did catch the Crown with certain errors, like if I ran that exact same trial and a judge alone, the judge would have probably still convicted and just established that, he could have provided justifications for his conviction on the circumstantial evidence. So because there is this underlying principle of adjudicating the case on the merits and not letting people off on technicalities, that feeling. Whereas I think juries take their oath seriously and are more likely to, in cases like that, apply the law strictly.
Now, I'm just going to ask you, though, Marco, on a very specific type of case, which is the sexual assault cases. These cases are becoming a little bit more complicated, not just because the law is changing, but also, judges are getting special training when it comes to these types of cases. We also have the media, if we want to talk about the juries, they're very much influenced, many of them probably, or I don't know, hopefully not influenced, but by what is being said in the media. Like we have the Me Too movement, and we have all these focuses right now on all these sex assault cases. Like every day there's someone who's accused of sexual assault. So these cases are very tricky, one way or the other. They're tricky if they're a judge alone trial, or even with a jury trial, because you also don't know what the politics of the jurors are. So what would you say, though, when it comes to sexual assault cases specifically? You've had, I think, jury trials in these types of cases. So what is your take on that?
Well, obviously, this is the type of topic that requires a more than this
Yeah.
short interview, and we can get into that at a later time. But for now, what I'll say is this: what you just touched upon is exactly what I'm talking about, in the sense that if judges have particular training on what to look for and what not to look for, and how to assess the evidence of a complainant in a sexual assault case in ways that we are not used to customarily in terms of their credibility or their reliability on certain things, they are going to, not make a big deal or not give a lot of weight to, let's say, inconsistencies that are somehow minor that we try to flesh out in cross-examination or various other aspects. And they might say, despite these problems with their evidence, I still find credibility meets the threshold of beyond a reasonable doubt, because first of all, they have experience and they see this all the time. And they have training in assessing the evidence, and they have training in assessing perhaps the way a witness testifies, the words they use, how they appear, and whether or not they believe them or not. And they can self-instruct in ways that could lead to a finding of guilt. But in a jury trial, I think people use their common sense more in terms of assessing what they're saying. Why would they do this versus why would they do that? Why would they say this? Why would they say that? And they apply their common sense, and then they're told of how high the standard is of beyond a reasonable doubt. And they're not told these are all the ways that you can be mindful of these parts of her evidence and how bad they are, and still convict. They're not really instructed on that. They're told about reasonable doubt. They're told about how higher standard it is. And then as defense lawyers, we can draw attention to, let's say there are minor inconsistencies, but there are 25 minor inconsistencies. You say to a jury, the Crown's going to say to you that these inconsistencies are minor, but we say to you, there's 25 of them. And the standard of beyond the reasonable doubt is very high. So did they get to that threshold? And it's funny because I remember when I started as a lawyer about 15 years ago, there was this, all the people of like my vintage or older that, let's say between 1 and 10 years at the bar, 15 years, you never run a sex assault in front of a jury, never run a sex assault in front of a jury. But all of the people that I spoke to who were more senior members of the bar in their 25 or 30 years old would tell me, I always run sex assaults in front of juries. I always run sex assaults in front of juries because juries are going to apply their common sense to the facts, and they're not going to, they're going to be told, well, we don't have sympathy, don't apply sympathy or prejudice. The idea back then was people are going to sympathize with the victims and sympathize and convict your client. So it's better to do a judge alone, because a judge alone is going to apply the law.
That's what we're seeing though with the Me Too movement. And the concern here with jurors is that their common sense also is derived from what they see, what they read about. So, I mean, common sense, yes, but also what is common sense for them, you don't know, right? So there is an element of risk because, you say they have to apply common sense, but what makes sense to them may not make sense to you.
I agree. And like, I think that if you have, especially now with the way the law is with 278 and 276 and the reverse disclosure obligations, if you have critical pieces of evidence that are going to undermine their account, we lost that element of surprise that plays well in front of a jury, let's just say. But in a judge alone trial, if those are compelling pieces of evidence that a judge in a judge alone trial will feel that it would be unsafe to convict on, then of course you could still keep it in a judge alone situation. But in terms of applying the common sense principles, the juries, it's interesting in the way the juries are now compiled. So we don't have challenge for causes anymore. We don't have preemptory challenges anymore. We only have challenge for cause. And then we have, oftentimes what the judge will do is provide a questionnaire to the jury panel. And one of those questions might be, are you or somebody been a victim of sexual violence? And if so, would that affect your ability to judge the case without bias or prejudice or partiality? And what you will notice then is that requires each juror to have a definition of sexual violence. They have to define what that means to them.
Mm-hmm.
And what I've been finding, because I've done 3 now in front of juries and many just in judge alone situations, but in front of juries, I've noticed that younger people, both males, females, and just the younger portion of the jury pool tend to have more commentary and experience with respect to being aware, victim, or associated to someone who's been the victim of sexual violence. And I think that has to do with their interpretation and definition of what that means. And so if you feel that, you, for instance, were sexually harassed in the workplace or something, you have that experience, it's something you're going to feel compelled to put on that form. Whereas people from an older generation, their definition of sexual violence might be, well, I've never been raped before, so there might be like an extreme definition.
Yeah.
And so they'll say no. And what I'm getting at is the cross section of the people that you get on your jury are not all going to be one, and they're not all going to be another. They're going to be a mixture. And what you hope to get out of that mixture is, some people will say, yeah, I want to believe the victim. And other people say, but we have to remember that the standard of proof here is high. Even if we do believe her, is it over the threshold that we need to get to? So there's always these competing tensions that you hope will get your jury to acquit your client versus convict. And when we go back to the original topic that you wanted to discuss here about jury versus judge alone, just think about it in another way. And I think a lot of people always focus on, they pick on me. I feel like I get picked on because I always advocate pick juries. But when the crowns have murder cases, you got to beg a crown for a reelection on a murder case.
Yeah.
They want the jury, right? They want the jury on a murder case. It's in rare circumstances that you can convince a crown to reelect on a murder case, because they know that for their case, when the stakes get high like that and the evidence gets in there, they rather have they don't want a judge to, why wouldn't they want a judge to decide it? If the evidence is so good and the case is so good for them, why would they always want a jury in a murder case? Right? Because they increases their chances of a conviction in cases where they might have gaps in their evidence, because they're asking the jury to use their common sense. It's circumstantial case. You don't want a circumstantial case, a judge alone murder. You might want a jury to say, here, look at all these pieces of evidence. It must be the accused who did it, or it must be that they did it intentionally.
Yeah. But okay, so that's at the trial level. But then there's also at the appellate level, because let's say, the verdict doesn't go your way, then you want to appeal it. I mean, it's a bit more difficult to appeal in a jury trial just because you don't have their reasons. You only get their final verdict. And then, you only have to go back mainly to the instructions if they were properly instructed. So, I mean, isn't it also trickier for the appeal?
It is. You're right about that. And what I typically do is I have appellate lawyer friends who I consult throughout the course of the case. If I find that there are issues that are arising in motions and legal issues and on the charge. But, when I run a trial, I'm worried about winning the trial. You want to protect the record on an appeal. I agree with that for sure. But you know who's good at protecting records on the appeal? Judges. So when judges write a ruling, they can write rulings oftentimes that are appeal proof. So if you're going to get that conviction in a judge alone trial, and you're going to get that same conviction in a jury trial, that judge alone conviction may still be appeal proof. Judges are, intellectual. They know how to write. They know where their issues are and how to try to close off those gaps. And even we've noticed now in recent appellate decisions that even where judges make mistakes, the Court of Appeals will look factually and say and be reluctant to send matters back necessarily. Right? Yeah. Because they could say
they have deference. Yeah.
They have deference, and they'll say even this mistake might not be enough to overturn the conviction. So you, as lawyers, we always have to be mindful of the appeal record. And I agree with that, but I can't, I'm not going to make the decision when I'm electing on a case whether or not I want a jury or a judge alone trial, simply because I want to create an appeal record. Because I want the acquittal. I want to see how far I can get with this case with an acquittal.
And Marco,
Mhm.
but I just wanted to ask you here, because you did also mention that, jury trials are also a good option, especially if you don't really have a defense, right? Like in these cases that you feel it's a loser case in front of a judge alone, you may have chances with the jury. But do you think that the lawyer's personality has anything to do with that also in getting the jury to go your way? Like, or is it
Every
just really the
lawyer
case?
is gonna want to pretend that they're this fancy
Yeah.
orator and present this case, and the jury loves them, and that's why they acquit. And you know what? I'm sure that that might have something to do with it sometimes or another. But the difference between a judge alone trial and a jury trial is in the presentation of, or the cross-examination or the closing address, the way you deliver it, the way you deliver your questions, the way you deliver your answers, subtle body movements and gestures that you make in a jury trial can leave jurors wondering, or you try to, witness is giving you an answer that you want to make the jury think is not believable. You can be a little sarcastic and be like, "Oh, really? Is that what you were saying? Oh, so this is the reason." And you ask questions like that. It maybe it agitates the witness a little bit, and then all of a sudden they kind of get thrown off a bit. Don't forget, they're testifying. There's all these strangers staring at them. You can go that way, or with police officers too. Like, you can just kind of tug on some threads that might not be there in a judge alone trial, because a judge would, I wouldn't even ask some certain questions in a judge alone trial, because in a judge alone trial, there's no legal relevance to it. And sometimes but in a jury trial, the jury might, one juror might hang their hat on one point. And when you bring it all together in your closing address, because what I try to do is I only try to ask questions and lead evidence that I want to comment on at the end. I'm not going to ask questions for no reason. And so when I'm commenting on it, I'll say to the jury, look, you may have been wondering why I asked Officer Smith about this. But the reason why I asked them, and I'll tell you now, is this. And all of a sudden it'll come together for them. Here's another question that is left unanswered. Here's another question that's left unanswered. And then at the end of your address, sometimes you have to say to the jury, with all these unanswered questions, how can you be satisfied beyond a reasonable doubt? And so you might take that approach. So yeah, it's the personality of the lawyers. Like, the more jury trials you do, the less stressful they become. Because I know that you've criticized me for my anxiety in other areas, but judge me for not having anxiety about doing jury trials. Well, it's because jury trials to me are a lot less stressful, because the judge kind of now all of a sudden becomes more of a referee. And as managing all the rules, and the jury's the arbiter. And we don't have to be always, it's not always about the law. It's not always about, being smarter than the next person. It's not always, sometimes it's just about the facts. And sometimes arguing a case about the facts, asking a jury to apply their common sense and their experience, is how you can maybe get an acquittal for a client that no judge would convict. Like, I've said that in pretrials, in Superior Court pretrials. I remember, is there any chance for reelection? I said, I don't think there's a judge in this building who would acquit my client.
Yeah.
So no.
But I mean, you did mention the stress and how, I did, pick on you on that when it comes to, because you sometimes mentioned that, how there are some stresses related to this job. And I, joked, and said that, well, maybe you should stop doing jury trials because they are very stressful. But so, first of all, I take it then you're not stressed when you're doing a jury trial anymore. You don't have that anxiety. Is that gone? Is that something that goes away after doing several jury trials?
It does go away.
Okay.
It goes away.
That's good to know.
Well, here's the thing. It's for a period of time, and a lot of lawyers, like I know, for instance, you interviewed John Struthers or Sid Freeman, and a lot of these lawyers who are doing, murder trials all the time, right?
Mm-hmm.
And of course, those are stressful, but those are going to be stressful whether they're jury trials or judge alone trials because the consequences are high.
Yeah.
So that's stressful. But when you're doing, like, in cases that are not murder trials, but they're still jury trials that are difficult cases that you have to run, the stress with the jury trial is you have to work every night. An issue might come up. You might have to make arguments in the morning on a particular objection or legal issue that arose. You don't have any time flexibility. So in that, I find like a 1 or 2 week jury trial a lot more stressful than, for instance, a 3-month trial. A 3-month trial, yes, but it's a lot of work, but there's ebbs and flows. Some days are very slow, some days are high intensity, and it starts to pick up frenetically near the end. Whereas in a short trial, there's an expectation that beginning to end, you get it all done in this time period. And so it does get stressful in the sense of it requires a lot of work. It's like a sprint. So you have to do a lot of work over a short period of time.
It's more focused.
So it's focused and it's stressful, and you don't have any latitude because there's 12 people who are taking time out of their life to be there. Right. So yes, it's stressful in that sense. But in terms of conducting the actual proceeding and conducting the trial, it's so much more interesting, in my opinion, because you're looking at these 12 people, you're trying to understand or guess what they're thinking. You're thinking, what am I going to ask of this witness? Am I going to ask nothing of this witness? Am I going to just stand up and say, thank you very much for coming here, but we don't have any questions for you today, right? And then the jury is going to be sitting there thinking, what was the purpose of this? Waste of time. Like, you just want to drop these little things that all of a sudden you're trying to make something out of nothing and twist what the Crown is doing in terms of leaving these questions with the jury, which is what I enjoy a lot, because then it becomes a factual advocacy approach as opposed to a legal advocacy. It's not about selling a judge or proving that your legal argument is principled and correct in law. It's not about that. It's about, how can I relate to these people? And so the more you do it, the more practice you get at it, the better you get at it, because you start connecting with your jurors. Like, I always write down their occupation. I write down their name, their occupation, in their little square on my little draft jury box, because I always want to know, hey, this person works, in mechanics and automotives. This person works as an office worker. This person is a cashier. I want to know what people are doing, because you try to convey, hey, maybe this person knows something. Or if something comes out when we're selecting the jury, I want to know that. Like, I make little notes of that, because it's something that, I remember we did a case where one of the jurors asked the challenge for cause. It was a race-based, and the juror was a white woman, and she says, "No, of course not. My son is black." And you remember that. It's like, I wrote that down because I knew that the racial component of this case is going to be a part of it, and I want to make sure that, like, it's nice to know that there's a person there thinking, well, the way the police treated my client is maybe the way the police would treat their son. And so it's like, you remember those little things, whereas judges are much better. Maybe it's because they see it all the time, or they're just a lot harder to offend, I think, in terms of what's happening in the investigations or what's happening. Whereas the rest of the people, they're a little bit more surprised, I think. So you can stretch those facts a bit and make something out of them. Ask them to consider it in terms of their determination of the case, which is what I like, which is why I do that. They are stressful, though, in the sense of work ethic, but so are judge alone trials. Right? Like, sometimes
defense work is stressful.
Defense work is stressful, and sometimes when you have, there's nothing more stressful than when you have a good and compelling legal argument, especially if it's a breach and you really feel strongly about the behavior of the police conduct, and the judge is also really intelligent and is battling back with you and making you see things in your argument, these holes in your argument that you hadn't considered or you did consider, but all of a sudden they've phrased it in a way that makes it not, makes your argument not feel as strong. That's stressful to me too, because your client is sitting there thinking, my rights are violated, and here's this judge who's basically saying, well, they were, but how bad was it? That's stressful, because they're not gonna, the advocacy on being offended by the conduct of the police or offended by the conduct of the state, doesn't really get that far. It's the judge is either going to be offended by it or they're not. Right. And in a judge alone trial, you depends on the judge you have that day. So I find it, and the other thing is the judges are very, very focused on fairness, in my opinion. And so sometimes there's a lot of splitting the difference. I can exclude this, but I'll let this in. I'll do that, but I'll let that. So that the trial is fair, And when you're in a judge alone trial, when they take that approach, it becomes much more difficult. It's very stressful, right? So in a jury trial, okay, well, what do I have to work with? Okay, I'll just work with what I have to work with. But we have to deal with our stress, Maya.
I know, and it seems like it's gardening in your case, Marco. We recently discovered through Twitter, so that's nice. That's relaxing. I have to agree that this is relaxing.
I enjoy in the springtime planting a vegetable garden. I plant a large vegetable garden, and I enjoy cultivating it throughout the spring and summer months. Every night I go out for half an hour, just water and just cultivate the plants and watch. And then usually by the end of July and August we have a lot of food to harvest: tomatoes, cucumbers, zucchini, etc. That's for me, that's during the summer months, that's definitely how I cope with my stress. But I just want to commend you for all the work that you're doing extra curricular from your clients and your practice. Doing things like this is a lot of work. I know I've done, as you know, I've done this type of stuff, and it's a lot of extra work. It's a huge time commitment, and it's very important to the profession. So I want to commend you on all your work, and I listen to your episodes regularly, and they're great. And you have great guests.
Thank you very much, Marco. And you're one of these great guests, and I'm very happy that you were my guest today. It's always nice to work with you and to chat with you. And I know we have more works in the projects that we're working on for Wicked as well, and other events and associations. So it's always nice to see you, and I don't want to take more from your time. I know you're very busy. So thank you for finally explaining to us why it is that you advocate for jury trials, and hopefully we'll have more people who will be doing jury trials from now on.
Well, I want for your younger audience, the first one is hard. The first one is super. They get easier as you do them, but you have to do them. And there's always a concern that you're being bullied out of them. That's the only thing. Judges, why do you want to take a jury on this? Why do you want to take a jury on this? Why would you take a jury? They make you feel like you don't know what you're doing. Why would you want to take a jury of this? But nobody knows your case better than you. And if in your gut you're thinking, yeah, you know what, a judge is not going to acquit my client here, but my client wants to run a trial. My client and they can afford it, assuming that there's no cost issues. Like, you have to factor in all those things. But if there is an option and it's available to you, then take it and just run them, and you'll be surprised. And I think people get surprised when you get that acquittal in front of a jury. You're thinking to yourself, wow, I convinced 12 people not to send my client to jail. That's a good feeling, and it's the type of feeling that makes you want to do another one when the time comes up.
Becomes addictive.
It does become addictive, and it's a lot more. There's a lot more tactical decision making that has to be done when you're in it. It's a lot easier to just ask questions and then write a factum and make a legal argument to a judge, and it's either going to go your way
Well,
or
it's
it's
not
not.
just tactical, it's also the other things that you mentioned, Marco. It's like emotions come into play in a jury trial. You don't really have that with a judge alone trial. So you can play on the psychology of the jury, or of, like some elements, like for example, that juror who said that her son is Black. So you can play on their emotions and appeal to that when you're making your submissions, where that may be less effective
Right.
with a
It's not even that, like, I would phrase it more of play to their experiences.
Mhm.
It's the
Yeah,
experiences of the jury. It's because you're not going to be allowed to, inflame the jury's emotions, but what you're going to be allowed to do is play to their, you're hoping that their collective experience and wisdom as a as members of our society is what's going to come
yeah,
to the conclusion that you want. And so you can play to those collective experiences. And it's a lot different than playing to the experience of a judge, because a judge is, I think, probably trained to, don't let their experiences dictate. They have to apply the law, and they work hard to not be biased or prejudiced by their personal experiences. Whereas I think jurors are expected to apply the law, but they rely on their collective common sense and experience.
yeah.
So it's a little bit different. It's a different game for sure. And frankly, it's just a lot more fun. It's a lot more fun because there's nothing better than an acquittal from a jury. I mean, maybe winning at the Supreme Court of Canada, which I've never been and probably will never be there, and probably for sure never win there.
Because you're too
But
busy doing jury trials. So.
but there's very little higher in our profession than hearing somebody read, not guilty. And if it's a multi-count indictment and it's not guilty, not guilty,
Yeah,
not guilty,
yeah,
each one feels better than the last.
yeah.
So do it and enjoy it. And I encourage everybody to do it, and just do as many as you can. Plus, everybody hates when we take jury trials, so we're supposed to be throwing
As if
sand
they
in the gears
didn't
of
hate
justice.
us enough, right?
Exactly.
Yeah,
We throw sand in the gears of
yeah,
justice to begin with. Nothing slows things down more than having to pick a jury and do a jury
yeah.
trial, right? So
That
just
annoying defense lawyer, and on top of that, a jury trial. It's like perfect.
exactly. I feel like that's the undertones that I get a lot. It's this guy always wants
All of
juries.
us. I don't think you're like, I think that's us in general. Thank you
So
again
thank you
very
so
much.
much, Maya.
Thank you, Marco, and we'll see you soon.
Okay, bye-bye.
Bye.